So I may now request Advocate P.B. Tiwari sir to kindly take over. So please proceed.
Thank you, Ruchi. Thank you, Dr. Anbhule. And this forum, LDF, is really doing a human job, for the fraternity. And see, so many lawyers have joined, 172, I can see. And all of them are so curious to know about the development, the the new laws, and especially the topic today, that is bail, when bail can be granted and when bail can be refused. This is not only academically important for everyone, but it is also economically important to everyone, all the lawyers, because bail is an important aspect of criminal law. When we say bail, it touches the liberty of an individual, and liberty is very sacrosanct. Now, the topic itself, which says that bail, when bail can be granted and when bail cannot be granted, has been elaborately discussed in the case of Harjeet Singh. Just write it down. Harjeet Singh versus Inderpreet Singh, alias and others, reported in 2021, volume 19, Supreme Court cases 355. Now, bail, this provision, as per the new BNSS, it starts from 478 to 483, and CRPC, it starts from 436 to 439. Now, bail, if you have a brief of bail, what you have to see is three things: whether the nature of accusation and the severity of the offense or the punishment, which will ultimately turn into conviction, and there are supporting evidence to that. There are three criteria that is laid down by Supreme Court when bail can be granted and when bail can be refused. One is the nature of accusation and severity of punishment in case of conviction and nature of supporting evidence. Two, reasonable apprehension of tampering with the witness or apprehension of threat to the complainant. Two. Three, prima facie satisfaction of the court in support of the charge. Now, if you have a brief and if your client is having these three categories and if they are satisfying, then bail cannot be refused. Secondly, every bail has its own fact, or every case has its own fact. Now, there can't be a straight jacket formula. म्हणजे आपल्याला स्ट्रेट जॅकेट फॉर्म्युला होऊ शकत नाही की हे क्रायटेरिया असा आहे, ह्याच्यामध्ये बेल मिळू शकतो, आणि हे क्रायटेरिया असा आहे, ह्याच्यामध्ये बेल मिळू शकत नाही. दिस इज देर इज नो स्ट्रेट जॅकेट फॉर्म्युला. द फॉर्म्युला फॉर दिस इज that there has to be three factors which need to be satisfied under the law: that the nature of accusation, how grave and how serious it is, and if you take the entire accusation, if it is taken on the face of it, whether ultimately it will run into conviction or it will not run into conviction. And secondly, whether there is a reasonable apprehension that this man who will be released on bail shall tamper or hamper with the investigation or give threat to the complainant. And fourth is prima facie satisfaction of the judge on the charge. Now, these three factors are the most important factors that needs to be evaluated at the time of hearing of a bail application. Now, if a bail, there may be a situation where a person is incarcerated for a very, very long time, say, for example, more than 5 years. As you know, Section 436A of CRPC has come into play, that if you have already gone into custody for more than 1.5 years, for more than half of the sentence, then you are entitled for bail. But even in that situation, bail can be refused if the antecedent of the person, is very bad. Even that antecedent has to be taken into consideration. If the antecedent is bad, you are not entitled for bail, even if you fit into the criteria of section 436A. Now, having said that, I will take you all to one judgment of Supreme Court where the Honorable Supreme Court has said, and which is followed in the case of State of Maharashtra versus Sitaram Popat Vittal. Just write it down. It is reported in 2004, 7 SCC 521. When you get a brief of bail, you just refer to the judgment because there are 7 parameters laid down by Supreme Court, which says that what are the points that a judicial officer or a court sees at the time of adjudicating a bail application. Now, number 1, again, in this case, the nature of accusation and severity of punishment in case of conviction and the nature of supporting evidence. Number 2, reasonable apprehension of tampering with the witnesses, what the judge sees, or apprehension of threat to the complainant. And number 3 is prima facie satisfaction of the court in support of the charge. In the support of the charge. Now, when I say prima facie satisfaction in the support of the charge, means the facts of the case, whether it is relevant to the charge that he has been charged for. There may be a situation that the facts of the case doesn't tally to the charge, or it is not a match to the charge. Charge and the facts are totally different. He is entitled for bail. Not only bail, you can straight away go under 482 for quashing also. Now, these 7 parameters. Third is danger of the severity of the punishment in the event of conviction. 4th is danger of the accused absconding or fleeing if released on bail. Character, behavior, means, position, and standing of the accused. Likelihood of the offense being repeated, and reasonable apprehension of the witness being influenced. And the last one, sorry, it is 8, danger, of course, of justice being thwarted by grant of bail. Now, these are 8 parameters that needs to be seen and that needs to be viewed in view of the judgment of Vittal, also in the judgment of Prashanta Kumar Sarkar versus Ashish Chatterjee. Just write it down. Prashanta Kumar Sarkar versus Ashish Chatterjee, reported in 2010-14 SCC 496. Now, these 8 parameters are important parameters laid down in a law of bails, where a bail can be refused or bail can be granted. Now, of course, the facts of the case of every brief is not the same. Every case is different. Every fact is different. But what you have to apply when you get a brief is these 7 parameters. If it fits, then you are entitled for bail. Because ultimately bail is a discretionary order. But Supreme Court says a discretionary order has to be applied judiciously. If the appellate court finds that the order has been passed in an illegal manner, or it is passed in an arbitrary manner, or proper parameters are not taken into consideration as far as those 8 parameters are concerned, as laid down in Prashanta Kumar, then in that case, the higher court is going to evaluate this in a proper sense to see that the man is released on bail. Because you can't incarcerate a person without there being any cogent reason. So therefore, the court says that there has to be a very cogent reason to keep him in custody. You can't keep a person in custody beyond a cogent reason, or if you don't give a proper reasoning. But you cannot release a person also by giving an unreasonable, or by giving a reasoning which is arbitrary, or or reason which has no backing of law, and release a person on bail. Because ultimately the judicial officer has to strike a balance between the society and the liberty. Now when society and liberty comes into the picture, there the important part of the adjudication officer or the judge or the magistrate comes into play. That how to strike a balance between society and the liberty of a person. Society is also important. Liberty of a person is very, 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 very important. If this man is released on bail, whether he's going to hamper the society, whether he's going to repeat the offense, whether the charges are such that ultimately it will turn into conviction, or whether he's going to hamper or tamper with the investigation, or whether he is a person who has no credential or he has very bad antecedent, bail cannot be granted to such person. But if the person is not having any antecedent, or if he doesn't fall into any of the 7 criteria, then the court can apply its judicial mind, and in a proper manner, or by giving a cogent reason, it can release a person on bail and allow him to go into the society and relive his life, so that he's brought back to the mainstream of the society. Now, this bail aspect of granting bail or no granting bail, I'll give you one example. In a MCOC matter, we have special laws also. Apart from regular bail that we are discussing, we have special laws also. For example, atrocity, for example, MCOC, for example, NDPS, for example, UAPA. These laws, for example, FERA, or you can call it PMLA, Prevention of Money Laundering Act. These are special offenses. Here, special provisions of law has been enacted by the Parliament, that when a bail has to be granted or when bail cannot be granted in all these special cases. Now, these special cases, why they are special is because all these special acts, they have rigor. म्हणजे रिगरचा अर्थ हे आहे की जे नॉर्मल ऑफेन्सेस मध्ये रिगर नसतो, हे rigor is only antecedent and all, but here Parliament has put a rigor कि you cannot give bail unless and until following conditions are satisfied. So these 5, 6, 7 statute or law, wherein if a person is arrested and his liberty is curtailed, here you have to follow the rigor. Here you have to go through the rigor part, and you just cannot shortcut the rigor. So rigor is what? Rigor is that you cannot apply for bail for a certain period of time, like MCOC. You can't apply for bail for 160 days. You can't apply for bail unless in NDPS, unless until charge sheet comes into the picture. You can't apply for bail in UAPA. You can't apply the case in PMLA unless until you satisfy the condition laid down under 45 or the PMLA Act. These rigors are also not that harsh that you can't get bail. Even Supreme Court is recently diluting all these rigors, and it has been granting bail. But there may be a situation that a person may be involved. I'll give you one example. A person may be involved in an MCOC case, and you get a brief of MCOC that you go and apply for bail. Now here you get to know that this man already had one MCOC earlier, and he is convicted in the MCOC. He has filed an appeal in the High Court, and High Court has granted him bail, and he's on bail in that MCOC. Now he is again attacked with second MCOC after say 10 years, 5 years, 8 years. He is in custody for last 5 years. Now the argument is that if he is in custody for 5 years, his trial has not started. His trial has already begun, but all the witnesses are not complete. Can this man be released on bail? So here the question is, there is a rigor under 21 of MCOC that if there is already a MCOC in which you are already on bail, and in second MCOC, can you get bail? Here, the court has to strike a balance between the rigor and the bail. The bail that is sacrosanct for any citizen of this country. So, in this type of cases, the court has to match a balance that how to support the rigor as well as how to grant him bail so that he can be out from the custody of that particular offense. So here the important question, similarly in atrocities matter, similarly in UAPA matter, similarly in PMLA matter, here there are all rigors that act. They are all serious offenses, and these offenses are adjudicated in a proper manner apart from these 8 parameters that I just told you in the case of this Vittal and the other judgment of Prashanta Kumar. Apart from this is also very important that the rigor, apart from this, rigor also applies. So the case of bail is not only static to the offenses, the natural offenses, or the offenses that are under IPC or now BNS. Not only that. So we have to see an overall view that under rigors also, how can you apply for bail? When there is a rigor, how can you apply for bail? Or when there is no rigor, how can you apply for bail? Bail, when you get a brief of bail, the only criteria that is that you have to see that the offense that you are charged for is not the allegation that is there in the FIR or in the charge sheet. If you are able to satisfy the court that the charge that you have been charged for and the allegation that is there in the FIR doesn't match to your allegation, then you are entitled for bail. For example, for example, there are 4 to 5 accused involved in a particular offense. You get a brief of the 3rd or 4th or 5th accused against whom there is the charges are very nominal in nature, or his involvement is not there. So, say for example, I'll take 307, earlier 307 BNS, IPC. Now there may be 5 or 6 accused. You get a bail of a person who was only standing by at the time when the offense was being committed, or he was a person who had no role to play, but he was standing. So now, while granting bail or while refusing bail, the court will see role of every accused, every person who are involved in this particular FIR or in this particular charge sheet. Upon evaluating their role, then and then only bail can be granted or bail can be refused at that stage. If you see always the magistrate or the session judge granting or refusing bail, if you are at a very early stage when you come for bail before charge sheet, they say that bail is refused at this stage because they want to understand what would come in the charge sheet, what would come after filing of charge sheet, what are the material collected against this particular accused, why we have to keep him in custody beyond 90 days or beyond 120 days in order to grant him or in order to refuse him bail. So bail becomes a very important criteria, and when a brief of bail comes to you, you have to put your client in the pedestal of these 7 parameters कि if तुमची केस या 7-8 parameters मध्ये बसते की नाही ते बघा आधी. If it is fitting in those 7 in those 8 criterias, then you are entitled for bail. But if it is not fitting into those 8 criterias at that stage, then bail can be refused. But you can always apply and you can always persuade the court. After all, we are lawyers. We are here only to persuade. We cannot have agitation. We cannot fight. We cannot shout. You have to be very sober. You have to persuade only the court. If you fit these 8 criteria of law, which is laid down by Supreme Court, and which says that if these criteria are there, then you are entitled for bail. And if you don't fall into this criteria, then you are not entitled for bail at that stage. So the law of bail is very technical and it is very specific, that you are having a brief where you have to see that the person is released on bail. And for that, you have to see the accusation that is there against him. You have to see the charge that is there against him. You have to see his antecedent that is there before, that is there. You have to see that if there is any rigor, under what section he is, and whether those allegations are competing to those sections or not, and ultimately what is the evidence before him. Now, in a white collar offenses where there is allegation of fraud, forgery, cheating, these are all are now these are all on rise. Now, in these type of offenses, it's a supposing there is a commercial dispute between two parties, and there is a fraud played by one of the party, there's a forgery done by one of the party, whether you can go and ask for bail. The answer to this is you have to see what is the involvement of your client in that forgery or in that fraud. If he is directly involved in the forgery, and forgery is a very serious offense, then it is very difficult for you to get bail, because forgery is an offense which would not give any entitlement to you to apply for bail, because there are chances that this man, after coming out on bail, he's again going to repeat the same offense. But you see that under what circumstances this forgery has been committed. Now, for example, there is one case wherein this man, this accused, had prepared a forged BMC receipt, and he prepared a forged demand draft, and he gave it to his partner, saying that I have already paid this demand draft to the BMC. He had sent this electronically by way of WhatsApp to the complaining, and complaining, after sensing some sort of doubt on him, he verified those receipt and those draft and found out that those both receipt and draft are bogus. They are false, and in that he has taken away in amount in crores. Now, in this situation, can you go for bail before any court of law? Because prima facie it appears that this man has committed an offense. This man has committed an offense. What do you do in these circumstances? Because this offense, it doesn't affect the society. This offense doesn't affect any other group, but it is between two individuals. But still, bail can be refused. So what you do, you have to strike a chord between complainant and the accused, that they go for a settlement of this type of matters, so that the amount that he has taken is paid to the other individual, and subsequently you can mitigate his offense, and you can go for quashing also by consent. So bail is not only restricted to white collar blue collar crimes. It is also now spreading its wings to white collar crimes, crime where forgery and fraud are at rampant, and also now POSCO, and then you have offenses against females, then offenses against persons who are at the workplace. So these aspects do touch the individual liberty, and day in and day out, every time we tackle this situation on bail, and then we are in a conundrum. It's a legal conundrum, like हा legal confusion आहे की आपण ह्याच्यामध्ये बेल टाकू शकतो की आपण ह्याच्यामध्ये बेल टाकू शकत नाही. Sometimes many of my friends, many of our you all, everyone who's listening, everyone, sometimes when we get a brief of bail, you are always confused whether we should go or we should not go. We take 10 opinions. काय करायचं ह्याच्यामध्ये, बेल अप्लाय करायचं आहे की नाही करायचं आहे. तर तुम्ही ते प्रशांत कुमारचा जजमेंट वाचून घ्या. Not once, you read it for 10 times. तुम्ही 10 वेळा ते जजमेंट वाचा. ती जे 8 parameters which is laid down by the Supreme Court You have to keep those 8 parameters in your mind. It's like a Bible. Just like for quashing, we have Bhajan Lal versus State of Haryana under 482. Similarly, as far as bail is concerned, this Prashanta Kumar, you keep it in mind that before taking a brief of bail, you have to go through those 8 parameters. And in your argument also, you can point out these 8 parameters to the court of law and say that I don't fit in any of them. Just like we point out in Bhajan Lal's case. Because when you get quashing of a matter, if your matter doesn't fit in those 7 parameters laid down in Bhajan Lal also, there are 1, 2, 3, 4, 5, 6, 7 parameters laid down in Bhajan Lal. If a case falls in any of those 7 parameters, you can boldly go before the High Court and ask for quashing of that particular FIR. But if your case doesn't fall in those four parameters, you will never get quashing. You will never get quashing. Similarly, if your case doesn't fall within those 8 parameters laid down in Prashanta Kumar, then getting bail is difficult. I am not saying you will not get bail, but getting bail will be difficult. Getting bail is only possible when you correlate the facts of the case that you have to these 8 parameters. And if you satisfy the judicial officer, or if you satisfy the judge, or you satisfy the DJ, की आमचा केस ह्याच्यामध्ये फॉल होत नाही, आमच्याकडे हे आहे, आणि फक्त ह्याच्यासाठी you can't keep him in custody. He has no other option but to release your client on bail. Because bail is sacrosanct. There is no alternate to bail. Supposing if a person is kept in a 5-star hotel for 1 year with all facility and you tell him not to come out, he will say, no, I just can't stay in a 5-star hotel room. I have to come out. So bail is so sacrosanct. You realize importance of bail only when a person is in custody. You ask a person who has gone into custody because the situation is so bad. So therefore, Supreme Court is also now very lenient on as far as bail is concerned, accepting those 5 laws that I told you regarding in atrocities, MCOCs, UAPA, PMLA, and all these subjects where rigors are there. When there is a rigor, you will have to wait for a longer time to get bail. If there is no rigor, you have to come out, provided you satisfy the judicial officer on these 7 conditions. If you don't satisfy this judicial officer on the 7 conditions, then there are chances that your bail may be rejected and your client may linger in jail for a longer time. Of course, I don't say that he'll be in jail for an unlimited time, but you can't say, because if his case is bad, he may not come out for another 4 or 5 years, and then ultimately you'll have to take the defense of Section 436A after a period of 5 years, and then you will get bail. But ultimately that will spoil his entire life, and he'll be of nowhere. So in this situation, bail when can be granted, bail when can't be granted, is a very typical and it's very tricky question, which depends upon facts of every case, because there is no straitjacket formula. These are all 8 points that we need to be highlighted, which we need to be seen. I hope this is sufficient. Or Ruchir?